You're welcome.
Well, good evening. It's nice to be here with everybody tonight. I speak on renewable energy issues all across the Midwest. I guess they're painting me as the con guy, though in truth I have no objections to wind or solar from a land use perspective. It's a question of proper siting in that we mesh the conflicting uses of land together in an appropriate fashion to minimize harm to all the players. So, but I guess you're going to call me con anyways, but that's my official position. We have very little time, so I'm going to skip over my credentials. But I'm a certified zoning administrator through MSU Extension. I started in Riga in 2003, so I guess I got 17 years now in on planning and zoning work. So the question everybody has is what's really proposed here in our community? Well, we don't know everything yet. It's still in development. But we know that ESA has applied for permits in Deerfield. There's a moratorium there. That's on hold. They applied again for conditional use permit in Riga this past week. It includes a lot of this section right here. I don't know where else they're seeking leases. There's also a moratorium there. There's a moratorium here in Blissfield and in Palmyra and in Ogden. So if wind turbines taught anybody in this community with respect to land use is that you can adopt a moratorium. We don't know what's going on here. Blissfield Township, of course, is a part of this. Obviously, there's interest in Blissfield Township, or Lindsay wouldn't be here speaking tonight. And what I'm hearing from some township officials is a theoretical footprint is Rogers Highway to Blissfield Highway, Rouget to Deerfield Road, perhaps north. Bottom line is anybody within 1 to 2 miles of a major transmission line could see solar development depending on what they do with respect to building new substations. Of course, it's cheapest for them if they can find real close access to an existing substation. Here's the site plan for the Carroll Road project in Deerfield. This is ESA. You can see it, Stadler, Carroll, Lip, and P Highway. If you zoom in, you see one of the things that I think is getting people's attention is that people's homes are largely surrounded by large solar arrays. So that's something that could be happening in any of the township footprints. This is a very small array compared to what's being proposed here. So now this talk is driven in general to policymakers. So some of it may be lost on the public, but these folks here have a lot of decisions to make, and I know there's township officials from other townships here as well. So where do we get our authority to regulate land use? In other words, how does the township have the legal authority to tell me what I can or cannot do with my private property, because that's what zoning means in the end? Well, it's through the Michigan Zoning Enabling Act. You can adopt regulations as needed to protect health, safety, and welfare, as well as regulate aesthetics, like the size of a structure, the size of a sign, setbacks, et cetera, et cetera. So as long as you have a rational reason for regulating those things, you're within the bounds of the law. But because I've been in so many townships in Michigan, and because I've sat at a planning commission table and not always understood what my full authority was and what I was supposed to be doing, we hear a lot of excuses. Criteria that sound good, but when you analyze them through the Zoning Enabling Act, aren't really that solid. So this comes from the Michigan Planning Guidebook. It's called Beware of Zoning Excuses. So here's a list of a few of them. Sad but true, far too many hearings on rezoning resemble a horse trading affair being carried out in a comic soap opera fashion. Some of the more ridiculous excuses offered for granting rezoning follow such lines as, you can't keep a man from using his land. This will bring in more revenue. The owner of the land can get more money if it's rezoned. They're too big of an outfit. We can't deny the rezoning. We don't have the right to say where commercial or industrial goes. He invested a lot of money. We don't want to have to court. After all, it doesn't really look that bad. According to MSU, those are not appropriate rationale for developing land use policy. The next theme that you're going to hear, because I heard Lindsay and Sarah speak last night in Riga, is we're going to hear something about state legislation that impacts renewable energy policy. PA 295 was adopted in 2008. It's our renewable energy mandate. It said 10% of our electricity had to come from wind, solar, biogas, or hydro. In 2016, Dale Zorn introduced an amendment, our state senator, to raise that mandate from 10% to 15%. Renewable energy developers cite this all the time to local communities saying, because of this mandate, you have to let us develop here. Some are that bold to say it that way, some are more subtle, but they bring this up all the time saying the state says we got to do this, so we need to move forward here. Because I heard that in so many townships, I went to Senator Shirkey in 2016, who's now the majority leader, and said, we got to have some clarity on this because developers are using this phrase to bamboozle local officials. He went to Representative Leuthäuser in Hillsdale, and he introduced an amendment, and it's now law, that says, nothing in this subpart abrogates the powers granted to local units of government under the Michigan Zoning Enabling Act. Just because there's a mandate doesn't mean you lost your ability to regulate this. Solar power plants are not a special class. It's like any other land use. Now, the other big one that's come up in the last 6 months, township officials will know what PA 116 is. It's basically a property tax rebate system. If you sign a contract to put your farm ground into PA 116 and you meet certain criteria and it depends on your financial performance, you can get some of that money back rebated on your tax. Until last year, if you built solar on farm ground, you'd have to buy your way out of that program first. So people weren't developing solar on farm ground much. Gretchen Whitmer signed an executive order and changed the rules for PA 116. That under certain and a long list of conditions, PA 116 ground can host solar. Unfortunately, we're now seeing developers saying because of those rule changes, you have to again let us host solar in our community because of this rule change. Well, what do the rules themselves say? By the way, at the end of this presentation, I got a big stack of documents, and you can all have a copy of these. So this PA 116 rule change says utility scale solar facilities may be permitted, not shall, but may, under certain circumstances. The first one is the land proposed for the facility is necessary to complete a larger in-scale solar facility. The rule clearly states that the percentage of ground in PA 116 must be a smaller portion of a larger project. In other words, all PA 116 ground is not open for development. Secondly, the rule itself makes it clear that this policy in no way interferes with the local jurisdiction's ability to regulate solar. It says one of the conditions is that the placement of solar panels has been approved by your local zoning authority. So again, it does not preempt your local control at all. Finally, it says Michigan Department of Ag and Rural Development can still reject this project even if those first two criteria are approved. Now the question is, what are the criteria they're going to use? When I talked to the fellow there, Jared Thalen, he says we don't have them yet. In fact, they've only received one application since June for a solar project that involves any PA 116 ground. So they're still in development. But the guy made clear to me that the intent of the rule change was not to incent solar development on large swaths of primarily high-quality farm ground, but rather to permit some solar on incidental tracts of marginal farm ground. I don't know how they're going to interpret it tomorrow. I can tell you that's what the fellow told me last Friday. By the way, those of you who have signed or have considered signing a solar lease, please get a copy of these regulations and read them for yourself, because the landowner remains liable for everything, 100%. You're liable for the bonds, you're liable for the removal of the solar panels and all the equipment. Yes, your lease transfers that liability to the developer, but 35 years from now, when it's your kids or grandkids, it's still in your lap. You don't know what entity will control your lease by then. There's a lot of risk there. Make sure you read this and not just the lease language that's offered to you. Solar developers have stated in public that these PA 116 rules require them to return to the ground to the original condition at the end of the project. And what they've been implying is that you don't have to worry about decommissioning and those kinds of regulations in your ordinance because the state's already got it covered. A substantial portion of the first project is not in PA 116 in the Carroll Road project. That means those state decommissioning rules don't apply. This is particularly troubling since at least one solar lease in the area says the developer shall have no obligation to remove any roads constructed on the property or any subsurface improvements. If it's not in your ordinance, they don't have to do it. Your ordinance won't change unless your community wants to change. I can't address everything in here. It would take an hour to go through those rules, but I have that rule in there, that set of rules in there. Secondly, what do you need to understand about your local regulations here in Blissfield Township? Well, there are two documents that regulate land use. The first is the master plan, which says here's where we want our land use trends to go in the future. It says literally, it shall be the township's responsibility to encourage the retention of farmland in agricultural production. That's your document today, in agricultural production. And it says the township shall discourage non-agricultural development of important farmland through the master land use plan and zoning map. Proponents of solar often make statements like, solar farming allows farmers to harvest a new crop, thus trying to paint the construction and operation of solar power plants as a farming activity. But your zoning ordinance already has a definition for farm, and they refer to the Right to Farm Act and saying we use their definition. Well, you can read the whole thing. Electrical generation is not listed there anywhere. By the way, we use the word farm to describe a lot of land use activities, but would we consider them agricultural? How about a tank farm? Would we consider that farming? How about an antenna farm? Would we consider that farming? This isn't farming either. Pretty simple. Your zoning ordinance makes it clear, the Right to Farm Act makes it clear, common sense makes it clear. Blissfield Township's ordinance is silent on utility scale solar. What this means is it can't be constructed here. It also means if you signed a solar lease in this township, you signed a lease to perform an activity on your land that's not currently legal. It's prohibited. Elmira Township's in the same boat, by the way. What does this mean? If Blissfield Township decides they want to permit utility solar on ag ground, they would first have to update their master plan and explain why ag preservation is no longer a priority, and then would have to adopt new regulations for solar. If they don't amend it, it can't be built, which means the question of whether this project goes forward rests in the lap of your township officials to beginning and end. One other note. If they adopt a set of regulations that the community as a whole finds objectionable, you have the right to referendum, and you can place that ordinance amendment before the people at the ballot box. Now, often we hear officials say, well, what about exclusionary zoning? If we write a regulation that doesn't let solar proceed like they want, we could be sued for exclusionary zoning. It's not that simple. The Michigan Bar has a 4-part test for exclusionary zoning. One is that you would have to exclude it. 2, there has to be a demonstrated need. 3, there's an appropriate location. And 4, the use is lawful. Well, you'd have a strong defense because in Blissfield Township, you already have electricity. Thus, there is no demonstrated need for new electrical generation in Blissfield Township. And the judge said just that in dicta in a case in Tuscola County 2 years ago. And secondly, even the PA 116 folks have serious concerns about turning high-quality farm ground into a solar power plant. Again, it would be easy to make the case that you don't have an appropriate place here. Summerfield Township just went through this. I brought your board a copy of their ordinance. They spent a lot of money and time on it. I talked to the supervisor. They wrote a solar ordinance that I like. They said utility scale solar goes on industrial ground. You can have solar on your farm if you're going to feed your own farm with it, but we're not going to convert our ground into power plants. Did they get sued in Summerfield? No, it just went away. So now I'm going to take a look at a few of these developer claims that we're seeing in the press and other places. But I want you to remember something. It's not the job of a planning commission to decide whether a particular industry is good or bad, economically viable, etc. The PC's role is to determine whether a land use is appropriate, and if so, where. Developer public relation campaigns are talking about often irrelevant issues. And I think they're attempts to misdirect the community into looking at the false criteria like those that I mentioned at the beginning of the presentation. Nonetheless, we hear them a lot, so I'm going to respond to a couple of these. The big one is that ESA has claimed tax benefits of about $18.5 million over 35 years for just the Deerfield project. But last week at the MTA convention, Josh Van Camp, who's an Ogden trustee, was there. Two big concerns. One is the gravel mining thing, so if you're worried about losing local control of that, call your reps. The second big one is the solar industry is pushing to be exempt from the personal property tax, which means you may end up with no tax revenue from the solar plant if that legislation were, or almost none. They would still pay some on like a substation and so forth. But that 18.5 would disappear. Another thing that happens though is developers talk about the benefits and they don't talk about the cost side of the equation. So, and here's the screenshot showing that it's an issue with the MTA. Of course, if you're selling a project, you want to think money and jobs, right? That's how you get the approval. We contacted Dr. Stephen Miller at MSU Center for Economic Analysis, etc. And he performed a model looking at the negative impacts of this project in the local ag economy. I will give you a complete copy of his analysis at the end of the talk. He determined that over 35 years, the economic harm to the community in Lenawee County would be about $52 million just for the one project. And of course, that would go higher with the project in Riga and even more so in the other townships. If we're going to be deceived into considering the alleged benefits, we should at least consider the modeled economic harm, particularly when they outweigh the advertised benefits by a large portion. If Samsung and ESA succeed in building these other projects, it gets a lot worse. I see no way to reconcile this economic harm to the ag industry with the Bushfield Township Master Plan, which states clearly that land use policies are to support the ag economy, not transfer wealth out of ag production and into a very small number of solar profiteers. That's something we need to consider. And I'm going to stop there. I have more slides, but it's hot and there's a lot of other people who want to talk. Email me, call me if you have any questions. I brought my attorney friend Josh Nolan here. If any citizens have any questions, feel free to talk to him afterwards. And thank you for your time.
Thank you, Kevin.